So I would say we start. Hello everyone, a warm welcome from my side. My name is Mirta Odoni and I work as a legal counsel at SIX Exchange Regulation. I will give you a brief introduction into this breakout session on how to prevent mishaps or failures in connection with disclosure obligations. And apart from the brief introduction, the main idea of the PowerPoint deck is to provide you with a tool to dive deeper into the disclosure obligations after today. This should help you to define the internal processes and responsibilities within the company, and this in turn will help to minimize mishaps. So, let's start with the regulatory environment. Under Swiss federal law, exchanges in Switzerland are required to establish their own regulatory and supervisory organization. This concept is known as self-regulation. It means that Swiss exchanges must have their own regulatory bodies like legislative, executive and judiciary. Those bodies must be independent from the exchange in order to avoid conflicts of interest. On the right, you see the organizational structure of the SIX group. Only the business unit exchange is subject to self-regulation. And on the right, you see the self-regulation put into force from the SIX group. First, we have the regulatory board. This is the legislative body which issues the rules, respectively, most of the disclosure obligations. Then we have the judiciary. Those are three bodies called Sanction Commission, Appeals Board and Court of Arbitration. And last but not least, there is SIX Exchange Regulation, which does implement and monitor compliance with the regulation, and it's the executive body. So, knowing the regulatory environment of the SIX group, that already brings us to the disclosure obligations. I think it's important to not forget that disclosure obligations serve a very important purpose by providing information to the market, and the resulting transparency contributes to correct market prices, which then in turn also protect the individual investor. On this slide, you can see an overview on the different disclosure obligations at SIX Exchange. I think take-home message from this slide is that not all disclosure obligations are laid down in self-regulatory law, but the obligation to publish a prospectus and also the obligation to disclose shareholdings are laid down in federal law, and therefore other authorities and appeal routes come into play as well. I will now give you a very brief introduction to those disclosure obligations, to each of them, but like I said, it's very short. So let's start with the obligation to publish a prospectus. Any person in Switzerland that wants to list a product has to publish a prospectus before the product can be listed. The prospectus needs to provide the essential information on the listed product so that the investor can base his or her investment decision on it. Due to time reasons, I can only deal with each of the disclosure obligations very quickly. However, on the slides in the outlined box, we always link to the legal basis and further information on the topic. So the deck will be sent to you after the presentation, so you are able to dive in deeper after today. I link the documents in English, however, they are also available in German and in French. The next and very central disclosure obligation requires the issuer to publish an audited annual report in accordance with the applicable financial reporting standard within 4 months of the balance sheet date. Additionally, issuers of equity securities are also obliged to publish a half-year report within 3 months of the balance sheet date for the latter. The publication of the annual and half-year report is one of the most important publications of an issuer, since it provides a lot of information on the company and is therefore crucial for transparency. In connection with the annual report, there is also the obligation that issuers with a primary listing are required to publish certain key information on corporate governance. This includes information about the group structure, compensation, etc. Additionally, issuers have also the possibility to publish a sustainability report within 8 months of the balance sheet date. However, this is based on a voluntary approach. Another obligation is to submit reports on technical and administrative information about the listed securities to SER and in some cases to the market participants. Examples of such regular reporting obligations are the date of the general meeting, change of the issuer's name, change of the auditor, etc. Issuers with a primary listing must use Connexo reporting for those reports. Also here, further information is always linked in the box. Let's already move on to the next reporting obligation, ad hoc publicity. Ad hoc publicity is the issuer's obligation to inform the market of any facts whose disclosure is capable of triggering a significant change in market prices. Annual and interim reports are the only per se price-sensitive facts. We therefore recommend that issuers establish internal criteria and processes to determine which elements or facts are price-sensitive. As the publication of a price-sensitive fact can also have a significant impact on the share price, it's very important that the publication takes place outside critical trading hours. We therefore also recommend that important decision-making meetings, such as the annual general meeting, be held outside critical trading hours. If a price-sensitive fact occurs, becomes known during trading hours, SER has to be informed immediately, and if then orderly and fair trading can no longer be guaranteed, SER will suspend trading. You can look forward to discussing specific cases on ad hoc publicity later during this breakout session with the attending experts. And with that, we move on to the next disclosure obligation, which is that executives or members of the board must disclose and publish transactions in their own shares. The report must be made to the company within 2 trading days of the transaction, and the company must then disclose the information via our reporting platform within 3 trading days. Last but not least, an investor who reaches, falls below, or exceeds certain thresholds in voting rights of a primary listed company must notify the company and the stock exchange. Also here, further information on the topic can be found in the box below. Last but not least, finally, I have also included a slide on how the self-regulatory disclosure obligations are enforced and sanctioned in case of a violation. Again, if you are interested in further information on the topic, we have provided the links to the relevant rules and also to the existing case law. To conclude, I'd like to briefly outline the key takeaways of this short presentation. In order to prevent mishaps in connection with the disclosure obligations, it is crucial to implement internal responsibilities and processes that ensure the correct fulfillment of the disclosure obligations, not only during business as usual, but also during, also in cases of unforeseen circumstances. To do this, knowledge of 4 pillars is essential. This is firstly knowledge of the regulatory landscape of SIX Exchange, secondly knowledge of the legal basis for disclosure obligations, thirdly knowledge of the relevant case law and other sources of information, and lastly also knowledge about our enforcement procedures. And with that, I'm at the end of my time. Thank you very much for your attention, and I will hand over now to Kilian.
So now we are going over to the practical part. This will be done by Kellerhals Karab, and interaction part with myself. but we'll start with a short introduction of the participants from Kellerhals. Karat first.
Good afternoon. We're happy to be here. I will firstly introduce ourselves real quick, starting with what we do, and then with who we are. What we do, we help other people, very specialized, in particular with a broad range of capital markets related work. So compliance in terms of insider trading, management transactions, publicity guidelines, or internal trainings, advice on specific issues like ad hoc announcement, management transactions, or significant shareholders, on 6 proceedings, the preliminary inquiries, sanction commission proceedings, or also regular reporting or general corporate work like General Assembly, invitations, corporate governance, ESG, website disclosure. And the heart of our practice, of course, is the capital market transactions. That is equity, capital increases or IPOs or debt capital markets. That also includes financing. Kellerhals, if you do not know it, it's the largest law firm in Switzerland with over 320 lawyers and 6 offices. And I'm here today with my colleagues, Emanuel Detwiller, Mark Hanslin. My name is Luca Bianchi, and we're happy to kick off the panel on how to avoid any kind of mishaps related to 6 notifications.
Quick word about myself. My name is Kilian Meyer, and I'm a co-founder of Interaction Partners. And Interaction Partners is a Swiss investor relations and financial communication software company. Maybe you have heard about us, respectively our platform Scheduler, as we work with 6 on Bridge. This means you can add events and news to 6 pages via Scheduler without being a client from us. The Scheduler platform, however, can do much more than that. We cover the following topics. First one is news. You can distribute your news via email to your distribution lists, ad hoc list, 6, and if you want, to AWP, Bloomberg, US, Yahoo Finance, and your homepage. Next topic is investors. We have a database of institutional investors that is maintained by us, and there is a CRM and reporting functionalities attached to it. Third topic is events. You can log externally organized events to organize your own events in person or virtually, and if you want to synchronize the events with 6 consolidated calendar and your homepage, you can do that as well. The platform is modular. That means you can only be a client for news or part of it, but the real fun starts when you use more modules. I'll give you an example. You set up an investor day, and then you decide that it should be displayed on the 6 consolidated calendar and on your corporate calendar on the homepage. Then you send out the invite and link the event into it so investors can sign up with 1 click, and they're automatically logged in your CRM. And if people not on your invite list show interest in the event via the corporate calendar or the 6 calendar, you can easily add them to the event. And after the event, you can collect feedback via the platform. Our latest addition are webcasts, where we use Scheduler for IR functionalities like validated participants list, the 1-click booking, and Swisscom for the actual webinars. And lastly, we do a little bit of IR advisory for a very limited number of clients with a focus on investor engagement. And that's it. Now the interesting part, why you're sitting here. We will discuss a few cases. It can be our cases or yours, or both. We have prepared homepage failure, problems with push emails, profit warning, early publication by accident. We will quickly describe the situation, preventive measures, and then there will be a legal opinion from the lawyers that are available to us today. If you have other cases that you want to discuss, you can bring them now, you can bring them later, and please always shoot in between with questions. We want to make this as interactive as possible, and as you all know, lawyers are usually quite expensive, but now you can ask questions without getting a bill, so take advantage of that. Let's start with the two general principles that are actually pretty easy and cheap. The first one is failing to prepare is preparing to fail. You need to have, for these quite expensive mishaps, you need to have a contingency plan available before you run into problems. You have to think about potential problems, and solutions, and test them. Improvising might work or not. In any case, it will be stressful. But maybe you are like the CFO of Six that likes his adrenaline push, then don't prepare. Then the second thing is a little bit of common sense will take you quite far. Humans make mistake, tech makes less mistake, but it's made by humans. So your processes should anticipate that there will be mistakes, and your process should try to minimize the outcome of it. I'll give you two examples. If you are sending around your ad hoc release you are preparing, and there are several parties involved, it's a good idea to have this password protected and have the password sent via a different channel. Most of you will probably do that, but if not, might be an idea. The second thing is, if you want to come up in the morning at 7 with a new ad hoc release, it doesn't hurt if you only start after the close of the previous day, because then if something happens, at least you will not get a big bill from Six Exchange regulation. You still can come out, and there is not a big problem. This is really common sense, so I don't think there will be any questions on this. Now to the cases. Situation, you need to distribute ad hoc news, but your homepage is down. That might be a DDoS attack, or you're just unable to upload the documents to your homepage.
Yeah, so cybersecurity issues have become a really big topic. You also see that, for example, FINMA published new requirements that apply for banks and financial institutions related to cybersecurity. But from a Six perspective, of course, the question is if, how, and when do we need to notify Six Air or make an ad hoc publication. So let's say you just have a technical problem. You want to make the ad hoc announcement, and the website just doesn't work. That's a basic scenario. In that case, best practice, in my view, normally, I mean, so maybe some cases would deviate, but normally would be you still publish the ad hoc announcements over all channels, except the website, because it doesn't work. You contact Six Air and inform about the web page, and then you publish on the web page as soon as it is back up and running. And whether that would trigger a preliminary investigation by Six Air is not clear, but in any case, this would kind of be the typical way to proceed. And whether there are any further steps would have to be discussed with Six Air. Now let's look at another scenario. The hacker attack is much worse than that. It might affect your whole production, not only the website. You might be facing ransom demands of hackers who have blocked your whole systems. That is an entirely different story. It's a crisis management required, and chances are high that it would require an ad hoc notice. But at the point in time where the attack happens, you might not even know what exactly happened. So what you would likely do is plan for two ad hoc notices. One where you inform the market that the attack has happened and that you kind of trying to figure out a way out of it. And a second one when you have clarity on the extent and maybe also already on a possible way forward. And then you publish the second announcement.
Any questions?
Yes, I have a question. Like if you want to have like the backup page ready or backup web page site ready, what so not only exactly this ad hoc release, maybe not even in the context of an ad hoc release, but just like in a normal day. But there's still information on the website that is required by SIX. So what really needs to be on this backup page?
You mean basically a copy of the web page, but with another link to access it, or the same exact address?
Yeah, we talk about huge content. We're talking about archives like years back of media releases. So it's not really So could it be a solution that you would have like maybe the last, I would say the last 5 media releases available there, and the content requirements? So
You mean like interim solution?
yeah.
I don't think it would necessarily prevent an investigation or at least a closer look to be avoided, because the requirements on the web page are quite clear, and it basically needs to be the issuer website.
But if from from a regular reporting standpoint, that's where the requirements are for what is the required content on the website. So one is your historic ad hoc notices, it's your financial reports, now with all the additional reports, and it's your calendar. It's your investment calendar. From the top of my mind, I think
maybe we ask Mirto.
I think it's clear in the regulation. I would have to look it up, but I think it's for the financial report. It is for the financial report. It's 5 years. It's 10 years. I'm sorry. From the top of my mind, I can't say. For the financial reports, it's clear. If you look at the practice, I mean, if, for instance, ad hoc notices, we have the flagging practice since 21, right? So I'm not sure that all issues have gone back and flagged their historic announcement, and I'm not aware that this has been picked up so far from SER. So there you have maybe 3 years going back or 4 years going back of history, but it's not clear. But maybe that is somewhere where the truth is, because a 3-year-old ad hoc notice is not price sensitive anymore. So maybe that is a sensible way, but of course there's no clarity on the ad hoc. For the financial reports, there is.
Last word, please.
Do we know of any case where there was a homepage down for an accident or whatever, and they faced litigation because it's available?
I think the angle we picked the primarily up is you violate, if you can publish on your website, you're violating the requirement to inform all investors over all channels at the same time. So that could be per se already a violation of the 6 regulations. For the regular reporting part, I'm not aware, we've not been aware for any sanction just because of that.
But I mean, the publication is kind of more a technical question where technical 6 requirements need to be fulfilled. But I was more kind of going in the direction that what if my operations as a company are affected, and then the web page may be the least of the problems of the hacker attack.
I also have a question. So regarding distribution, so you were describing kind of this in your case, operations is down. Let's say the website doesn't work anymore, but also the tool to distribute the ad hoc release. So what will I do in such a case? Maybe I have some kind of email addresses, or alternatively, can I put it on LinkedIn, or is there like a scenario for that?
That's a different case. We'll come back to that. I think.
Shall we? I mean,
You can answer it, right?
shall we talk about that one?
Yeah.
Yeah. So the bad news is a bit if your emails don't go out, or you have issues distributing your emails, or you're only serving certain channels. And for instance, not the subscriber, you're only informing the newspapers and not the subscribers. There's not much tolerance at SER for that. They say this is a basic procedure, and they expect issuers to be able to manage that procedure. So what So this is, the prevention point that Killian mentioned earlier. If it happens, SIX appreciates information to be informed, and appreciates if an issuer is able to distribute the emails in a different way. So they still would expect you to use the same channel, but just maybe with a delay, and from your perspective, using a different platform. I mean, if you use a tool for the push, maybe you do it manually. And also, what SIX looks at in its sanction practice, how quickly are you able to discover the mishap? And for the push email, they said it was sufficient that you just copy yourself into the email distribution list, so you immediately would see, do you get the email or not? If you don't get it, the control mechanism that allows you to quickly detect the issue. So maybe on your question, not a different channel, the same channel. Fix it as quickly as possible, and inform SIX.
And certainly have a redundancy available, or some backup solution.
And on that, if I'm not mistaken, there are cases where SER has sanction issues.
Yes, because yes.
Yeah, I think even 3 cases recently.
There are generally a lot more sanctions than years ago. So this is kind of interesting to follow. It gets more and more difficult for companies to be compliant, apparently.
We'll come back to that email push thing later. I have still a question about this alternative homepage. I find the idea quite interesting, but do you have any idea what the requirements are of that address? Because obviously it needs to be a different host, it needs to be a different domain, otherwise it will be down. So how easy must it be to find this alternative homepage? Because if it's there but nobody finds it, does it solve the problem? Sorry.
I mean, I can't answer that for Sarah. I mean, there's one domain on an issuer's page on the SIX website, and probably Sarah would, as a principle, expect that an issuer information is found on that page. If you can find it in different ways, let's say Google, maybe that helps, like your common sense approach, but I'm not sure that such a backup page would be up high enough on Google for someone to see it. So, I mean, just the technical question would be maybe, is it, if your website is down, are you able to have a forward address, like under your normal domain, and have it forwarded to your different website, whether that is possible? Because
if you add it to the push email, new documents can be found.
The issuer's webpage must be communicated to SIX, and then basically, once it's communicated, then it's clear which address it is. So it doesn't prevent you from being in breach.
So I like your idea, but it seems to be technically quite complicated. You can have a new domain, you can have a different hosting, everything can be up, but we might still run into problems. But probably the fine will be lower. So a few words from kind of a technical perspective on homepage. Generally, there are people that pick the cheapest hoster they could find, and then there is a little bit of traffic and the homepage is down. That is easy to avoid. If it's $9.90 a month, it's probably too cheap. The second thing is you might have your assets, the files, have on a different server. Then at least the links will be accessible in the email. That will also not help you with SER because it's a different channel, but it increases the kind of convenience for the recipients. And then that's obvious if you can have someone from your IT available during ad hoc, so you don't reach him because he usually starts only at 9. That helps, and sometimes it's also only a problem to upload into a specific section. So if you can implement a banner on your main homepage, I think that will also already help you quite a lot. And if you are trained to do that yourself, that would be nice. Questions on technical things?
No, actually. actually have another question. I mean, if we know it's an ad hoc publicity duty because we're acquiring a company and the voice net or the signature is on paper and we need to publish the next morning, but now the distribution system or the whole page goes together or down. Would this be sort of a reason to push out the publication deadline?
In this case, no. You still need to publish before the market opens to all channels, and then just fix the web page as soon as possible, but later.
This is my question again. How do you publish? How do you publish on the system work? Is LinkedIn accepted or not, for example, or?
No, I mean, these have to be the channels that you have to use for the ad hoc notification. So it will be published on the 6 web page for once. Then you have to send it to, I believe, two newspapers and a media agency, etc. And so basically, it's not the web page; it's more whether your emails may not work, or there are other technical problems. The example was basically targeted to describe the situation where only the web page does not work, but the remaining tools like emails, etc., are still running.
But again, on the LinkedIn question, I mean, we said, gesunder Menschenverstand, but on the channels, Sarah has a very formalistic understanding, and it's not the question whether, even in the push email case, SIX doesn't look at whether the market even reacted to that, whether there was an impact on the market. The Sanction Commission did not really consider that. They already said it's a fault, and sanctioned it anyways.
And I would even consider it a violation of the form of the publication if you would publish it via LinkedIn and not on other sources.
It is, yeah.
I mean, you basically would have to consider it might be a breach to do that per se, because if you inform the market kind of in a wrong manner or the wrong channel, that also has a detrimental effect, right?
First row, please.
I mean, bottom line is, if something happens, you inform Sarah, but they will take it up anyhow because you violated the regulations. And best thing might be that the fine might be reduced a bit. That's all. But you get the fine,
It depends. It depends on the case. It depends on the.
It depends on the case. It depends on the arguing. It depends on how you reacted, and again also how you argue when defending yourself, obviously.
So and now the not lawyer speaking. So homepage checking if the homepage works. Yeah, please. Checking if your homepage works. You have to look at 7:29 if the homepage works. They cannot check all homepages at 7:29. So you might gamble and hope that you publish at 7:35 and nobody at SER becomes aware of it. There will be no fine, no problem. But if they become aware of it, you did not report and you are in more trouble. So that's a commercial decision you have to take. But I don't think SER is checking all web pages every minute of all. So
I mean,
a few minutes you might get away with it.
It's not that this happens a lot, ideally. I mean, in the last 20 years, I don't think I ever worked in a company where the web page didn't work. And so I would kind of see it in a way that the standard for an IT and operations of a web page and system for a listed company are just higher than, let's say, for a startup, and you need to be ensured that the daily operations work, and then it will not or very rarely even happen that you are in this situation.
How flexible, I don't know if you have experience with that, in terms of simultaneous publication. I mean, in my experience, you press the button, and it takes about 3, 4, 5 minutes till all your emails goes out. It might take 2 or 3 minutes till your homepage refreshes. I mean, obviously go out 7, so we don't miss the 7:30 deadline. I mean, this is acceptable, or is there something that worry you.
Yeah.
And the second question in that respect, it's also dependent on your external provider, right? It's not that you have control over your, in many cases, your distribution. I assume that's not a sufficient excuse.
No.
No, that's not, whatever your third provider does is what you do, basically, so that's very clear. But I think as long as it's up to sort of what's technically possible nowadays, that's sufficient. You cannot, Sarah cannot ask for something which is technically not possible, but as long as it's state of the art, that's fine.
And before 7:30 in the morning.
And before
Yeah.
the last one is
Probably that is where the sensitive point lies.
The problematic cases are those where one part of the recipients does not get the notification at all. If it's only a matter of seconds or minutes, I think that's plausible.
Yeah, I think we are talking minutes. If you have a distribution list of 4,000 people, you cannot serve 4,000 people in a minute. It's, and I know what I'm talking, it's very difficult, not possible.
And even if you had like a much more expensive solution,
But then actually the faster you send, the higher the probability is that it will be considered spam. So there's also a trade-off there. So 500, 600, 700 a minute, easy. Beyond that,
it's really only relevant that it is going out before the trading opens. I think that's the important aspect. And maybe there is, just in brackets, a different story if you're forced to publish during trading hours. Maybe then it's a little bit more difficult or a little bit more tricky. But generally speaking, well, then you're in a special situation.
possible.
Now, one question. I mean, we have to accept that sometimes technical issue can happen, right? That's not always in our hands. We can prepare, but it's not always in our hands. For me, the question then is it always good to proactively and early on inform SIGs? Yeah, give a call and say, listen, we have this or that problem. Or also, if in case of an IT incident, yeah, and, is it the right way just to call? Better call early on than waiting. Or also here, is it sometimes better to wait and sometimes better, to early on call? How is it perceived? Do you have experience of your clients maybe? Is it perceived positively?
So if you call early, if you inform early, it's certainly perceived positively and would have an influence on any sanctions proceedings at a later stage. But again, I would perhaps also go with what Gideon said. If there are situations where you basically have to weigh, can we still fix it within reasonable time without actually causing any damage to the aim or the goal of the whole ad hoc publicity, which is market transparency, and then you basically have to weigh that a little bit one against the other. Is it? I wouldn't wait too long with a call, but maybe you can wait for a few minutes and see, can we fix it quickly, and then it's done. If you cannot fix it after a quarter of an hour, then I think that's definitely the time when you should call.
but you're not early when you call early. You're early when you have a proceeding in place on how to deal with these kind of situations to figure out what the next steps are. So basically the prevention starts before the problem arises.
Not sure, but as said, I mean, you just cannot always.
Yeah, I agree.
Just one question, probably a follow-up question to him. Mitigation strategies to bring down, the level of fine. What do you see there in practice?
I mean, that is really inform. I mean, if you inform SARE, they appreciate it. They will consider it in their sanction proposal to the Sanction Commission. Sometimes they will consider this also and say that this will reduce the fine that they apply for, but it's not a guarantee. It's not a guarantee, but they will mention it positively. And the other thing is how quickly you're able to react. So how is your organization? What is your plan B? And how are you able to correct the situation? I mean, for instance, it's a different case, but it's our last case. But if we take the two cases where the annual report was not visible on the website, but crawled from website crawlers, so they were hidden, but technically some citizens were able to get data from them, and one issuer didn't want to publish the next day. The publication date would have been the next week. But what they did, they informed SIX and published the next morning, so advanced the publication date, and that was also seen positively by sales. So it's, you inform them and you react quickly, and then it's all other things like aspects. What is your organization? What have you done in the past? How compliant have you been? Are you accepting the mishap? Are you taking the responsibility for the failure? And what do you do to prevent further failures? These are further aspects that they will consider, but it's not a guarantee that they reduce the sanction because they say you're a listed company. That's maybe what we expect anyways from you. But if you don't do, that could even increase the fine.
So I think we can move over to the second case, which we almost completely covered in the meantime. The ad hoc emails not going out. Legal assessment, you are in trouble.
Yeah, I mean exactly. I cannot. I would only repeat myself. So you're exactly. If that happens and is not remedied before 7:30 and SIX realizes it, you're likely to have a preliminary investigation on that. It doesn't help if you use a third-party provider, also as said. But SIX says you are allowed to use third-party providers. So it's they completely acknowledge that for certain procedures, third-party providers are used. But if something goes wrong with them, the failure will be attributed to the issuer. And the third point I just talked about is how do you react on it?
So from a technical perspective, I won't go into too much details, but there are ways how you can set up a service that are safer and some that are less safe. And of course, the safer ones are more expensive. I'll give you one example. A so-called active deployment means you have the app running redundantly on 2 servers in parallel, favorably in 2 data centers. It's quite complex to set it up, but if one data center burns down, you still will not see anything. So probably ask your provider how they are set up for that. And then you have to have a plan B. And one plan B could be, there are kind of cheap marketing email providers, and some of you guys have used them or are still using them for ad hoc distribution, which will be fine probably in most cases. But let's say you take MailChimp or Mail Expert, Cleverreach, I'm just giving you some names. They are not expensive, and you could set them up as an alternative distribution tool. What you need to do is you need to download your distribution list from your main system. You need to download the ad hoc list you're using on your main system, and you have them ready in the morning, so you can just put maybe only the text in the alternative system and then upload the distribution list and fire. That will probably take you 10 minutes. If you want to be even more safe, then you prepare everything redundantly. So you have the distribution list uploaded, you have the email ready, but you are only sending it if your primary distribution fails. That's the luxury solution. It will add, let's say, 20, 30 minutes, 20 minutes to your preparation time, I guess. The second option, and that works for smaller companies, Microsoft Exchange Online, you can send 500 emails in one go, send a test email to yourself in the evening, remove the test, and have your distribution list ready, and then you can send it from your own emails. But you will probably run into problems if you have more than 500 recipients on that list. And don't try it from Outlook desktop. That might be an issue. Online is the safer version. Questions?
Probably just one question on my CEO would ask me now, what is the cost benefit if I need to factor in a fine level? What are we talking about in terms of fines?
That's your call.
I can't tell you for all of the cases, but I think it's all around a small six-digit number, 100,000 plus minus. I think in most of these cases, even though the companies concerned were of quite a different size, but also for the smaller ones, which maybe is the bad news, they also got into the six digits, 100,000, I think. And the largest one were, I think, also in that region, slightly higher. So, it's sanctioned. It can be a significant number, or it is in absolute terms a significant number, but it's not near the 10 million maximum fine.
So I think there was one case where there was a partial problem with the email distribution. I think retail investors were not served, and that cost 90,000. And I think Cleverreach or MailChimp you probably get for, 200 a year. But it's additional work. And you have to test it too, because if you have the system and you never tested it, so basically what you need to do is you need to test your backup system with the non-ad hoc news. So you know that everything works. Because if you have a backup system and first time fire and then doesn't work, all the work was for nothing.
Maybe a Christmas card would be nice at this time of the year.
Yeah, Christmas card, yeah. If they are not too fancy, because then the dancing Christmas tree probably is not a good idea for that, because that's not your normal ad hoc release, and your test should be as close to reality as possible. So, then I think we can switch to the next one, and that's an interesting one. Situation: you get your full year results, and your net profit is 11% above your full year guidance.
Yeah. This is certainly one of the more trickier cases. The whole profit warning, profit hike, profit loss. Then you have to. I'm sure you're aware that if you give, basically there are two situations. You have a profit loss or a profit hike, which is compared to your last year's figures. Or and then you have to do an ad hoc publicity if you have a significant deviation from that, or if you have given some guidance to the market and you're deviating from that. Notably, you would have also to give go out to the market with a profit warning. Sorry. As soon as you got the final numbers, basically. Yeah, and there is actually a case where there were the final numbers available, like 10 days before the announcement of the annual result, and then the company decided to announce the deviation only together with the annual results, and that wasn't well perceived by.
means audited or just internally?
I mean.
Preparation.
So in the one case which led to a significant fine, but there was also different circumstances which led to an increase of that fine. It was when the company knew the numbers, so it's not the audit in the end. So it's from the consolidation process through the group, when it was clear, when it was reviewed by the CEO, when CFO discussed with the CEO. And also, SER would have acknowledged that this also needs to be discussed on a board level. So you maybe have 2 or 3 days to be really sure what is the situation and how you want to deal with it. So you maybe have 2 or 3 days, but 10 days was certainly too late. Yeah.
Yeah, you certainly have to be sure about the numbers. Obviously, there may always be a slight deviation if the auditors check the numbers, but typically you should be pretty safe on what your numbers are, and I think one perhaps aspect to consider when giving guidance is you should have sort of internal rules, internal guidelines on when to give guidance on which KPIs, you give guidance, and there it's for example it's important that you don't give guidance on too many KPIs, because then you're confusing the market, and it also makes it difficult for you to decide whether you would have to go out with a new ad hoc publicity, ad hoc notification, if your guidance on certain KPIs is missed, and on others it is, you actually reach it. So one way to avoid also having to go out too much with too many ad hoc notifications is you give a guidance in terms of the range. So you say our KPI, our earnings are between X and Y expected, or you basically give a range, and that certainly helps to give some to limit the number of notifications which you have to publish on that topic.
Yes. There's a question.
And when you're speaking about compared to the actual results, how compared to guidance, and you're speaking about basically the written guidance in the analysis, in the written communication of the company, or is it, does it also play a role where the consensus is at? So of course you can have in your discussions with analysts, they can have reached the conclusion that your actual results will be maybe higher or lower than the guidance. So what is the one that is the most important? Is it the consensus that actually is more important for the market? Or is it the written guidance?
It's your guidance which you've published, yes. And it may happen that you're confirming a certain consensus in the market, but then again that may trigger the need for a notification at a later stage. But generally speaking, it's your own guidance. But it also a little bit depends on the situation. If the situation is that, you know, because there is like an external event like a pandemic or a war or whatever, then that everybody sort of expects the market to be lower, then that doesn't necessarily then trigger the need for a notification if you are below, even slightly, you know, at the lower end of the guidance you gave, for example, or even slightly below, because that's what everybody would expect. I know this is debatable, but
the ad hoc publicity concerns events within the sphere of the issuer. So outside events may be irrelevant, but if they indirectly then affect the sphere of the issuer.
But a war, for example, has a direct effect on a defense company, for example. You know, so everybody expects that would have a direct effect, for just as an example, or a pandemic on the pharmaceutical sector.
Yeah, and the consensus, sorry, last point to add on, the consensus is something like a rumor in the end, like from a legal point of perspective, is an outside fact, and the issuer is not obliged to correct rumors in the market. So if you give a guidance, fully agreed, probably the consensus is not that relevant. If you have no guidance out there, and then the deviation is probably measured from your historical performance and what you've done, maybe there the consensus can be relevant for you to understand how does the market, you know, what is the market perception, because given that we didn't give any guidance.
Let's rephrase that question. Let's say we are 10% above guidance, exactly where the consensus is. Basically, as an issuer, I would expect zero market reaction if we come out. Would we still need to issue an ad hoc profit warning because we are 10% above guidance, but exactly where consensus is, and the market impact will be most likely zero?
My personal opinion is that I think it is against the actual goal of the ad hoc publicity to go out in such a situation. But I would recommend to be on the safe side and still go out.
I mean, we certainly have a discussion on it. I mean, I think it's the choice between two possible wrongs, right? So probably you could go either way and would have to make a decision based on certain considerations and document what you believe. I mean, if your argument is this is not price sensitive, because the market has already priced that in, we are super in line with the consensus, then you have to document why you believe this is the case. So if there is a preliminary investigation, you can show your reasoning. And actually that is what price sensitive is. The issuer needs to make a decision on whether something is price sensitive, and it needs to make that decision in advance. So SARE should, in an ideal world, only look at your decision from that point of view.
In an ideal world, that's why I said they would.
That actually brings us back to the kind of process from investor relations perspective. So you are in investor relations, and then you are confronted with that situation. And if you then start to ask yourself, what do I need to do? Then that will probably already cost you half a day. But if you have an internal rule, let's say 8% above below guidance will trigger an email to CFO and general counsel, and they know which lawyers to call, and then there will be the facts presented, and then there will be a fact-based decision. Then you are properly documented for SARE, whatever you have decided. But also, generally, you will not get punished for sending out an ad hoc release that is not a real ad hoc release.
And I think one very important...
In that case.
And very important aspect with regard to guidance is consistency. Just be consistent over time, over the years.
You want to say something about the non-ad hoc release being...
Yeah, I mean, I think you said it, or everyone in the room said it as well. Yeah, I mean, from the regulation, you're not allowed to label a non-ad hoc release as an ad hoc release, so you could be, of course, punished. But this is one of the cases where your discretion I mean, I think that's what you meant, where your discretion is so big that probably SARE would not take it up either way, or you have chances that SARE doesn't take it up either way.
So in that case, if there are no PR or commercial reasons that speak against an ad hoc release because you don't want to come out right now where you have planned something, then you might err on the side of caution and just issue it and be properly documented. 10% figures are confirmed, consensus probably a little bit outdated, documented decision was based on this, and then I think it's safer to err on the side of caution in this case.
Yeah, exactly.
I believe the time is up.
Time's
Okay.
up, so you're missing out on the scraping thing, but in the end, scraping, the bots will get you. If you put something on your homepage, you will be responsible for it, and the bots are getting better. So only do anything after 5:30 or 5:40, and there are no such things like a non-public part of your homepage.
Thank you.